All right, here I go. Welcome, everyone, and thank you for joining Seyfarth's webinar on California wage and hour class action litigation, key recent developments and trends. All participants are currently in listen-only mode. If you have any questions during the program, please use the Q&A box located on the right side of your WebEx window. We'll do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write the code down as it will not be repeated and is necessary for you to get CLE credit. CLE credit submission instructions, the presentation recording, the slide deck will all be distributed to attendees in the days following the presentation via email. First, we have to show you this fascinating disclaimer. Okay, everyone got it? Thanks. Your presenters today are Michael Afar, Chris Crosman, that's me, and Carrie Friedrichs. You should feel free to call or email us with any questions you may have, either regarding this presentation or any other labor and employment issues that you may wish to discuss. Today, we have many exciting developments to cover. First, Seyfarth Shaw has just released the 20th edition of the leading publication in the field, Litigating California Wage and Hour Class and PAGA Actions. It's been updated with all the recent major legal developments, and we'll be reviewing many of them today. Now, some of these developments are so new that a few of them came out after the book was published, but don't worry, we'll bring you all the way up to date during the webinar. The agenda for today, as you can see, includes recent developments in the law affecting Private Attorney General Act claims, the current status of California law concerning classification of independent contractors, the latest state and federal decisions affecting class claims for off-the-clock work, and other key recent legal developments in wage and hour law. Unfortunately, many of these developments are not very favorable to employers. But don't worry, we, your friends here at Seyfarth, are ready to help you navigate your way through these treacherous waters. Okay, so as I mentioned, the 20th edition of Seyfarth Shaw's Wage and Hour Class Action book has just come out. That's right, we've been publishing this book since back in the day when the stock market was plummeting due to the bursting of the dot-com bubble. And children who were born when this book first came out are now juniors in college. So there really are years and years worth of defense-oriented legal analysis and advice packed into this one volume. Here's the cover of this year's volume. As you can see, we don't have much of a design budget for our publications, although I think the color is nice. But what makes this book really special is what's inside of it anyway. The book is free and is available in a handy ebook format. You'll be sent an email with instructions on how to download your copy. The book covers a veritable plethora of key issues facing California employers in connection with wage and hour litigation. From expense reimbursement to meal and rest claims, unfair competition claims, representative actions under PAGA, CAFA removals, class certification and how to defeat it, class discovery issues, class action waivers and settlements of class actions, all from a defense perspective, including strategy pointers and the case citations you need to make winning defense arguments. In addition, the book has a handy statute of limitations reference section to help you keep track of the differing time periods applicable to various types of claims, as well as a table of cases and an index of key terms to make it that much easier to find what you're looking for. Okay, now on to the recent legal developments. First, we'll cover developments affecting representative actions under the Private Attorneys General Act. Perhaps the most significant recent development affecting PAGA claims came earlier this year when the California Supreme Court issued its decision in Kim versus Raines International. There, the plaintiff had sued his employer, asserting that he had been misclassified as exempt from California's overtime laws. He filed a combined class and PAGA action based on the same underlying alleged wage and hour violations. The employer then compelled the plaintiff's individual claims to arbitration, with the PAGA claim being stayed pending the arbitration. Once in arbitration, the plaintiff settled his individual claims, while the PAGA claim was carved out of the settlement. The employer then moved for summary judgment on the PAGA claim, and the trial court granted summary judgment on the grounds that the plaintiff's rights had been, quote, completely redressed, end quote, by settlement, and that he was no longer an aggrieved employee eligible to sue under PAGA. The Court of Appeal upheld the ruling. However, the California Supreme Court reversed. The High Court focused on what is required to have standing to sue under PAGA. The statute provides that a PAGA plaintiff must be an aggrieved employee, which is defined as any person who was employed by the alleged violator and against whom one or more of the alleged violations was committed. The employer argued that the plaintiff was no longer aggrieved once his individual claim for relief was settled. The High Court disagreed, citing PAGA's statutory language, the statutory purpose of protecting employees, and the overall statutory scheme allowing aggrieved employees to sue on behalf of the state of California. The High Court concluded that an employee does not need to have an unresolved injury in order to pursue a PAGA claim. Instead, aggrieved employees retain standing to sue so long as they have allegedly suffered a relevant labor code violation. Settling an underlying labor code claim for such a violation does not make the employee any less aggrieved. Now, Kim versus Raines is a bad case for employers. However, it remains to be seen just how far the California Supreme Court's reasoning will extend. A previous Court of Appeal decision, Villickers v. ABM Industries, had held that class action wage and hour settlements, which was judicially approved but did not specifically include a release of PAGA claims, created a res judicata bar to settlement class members pursuing subsequent PAGA actions for the same wage and hour violations. The court in Kim versus Raines distinguished Villickers as being factually different, but otherwise the court left that case alone. Kim v. Raines leaves a number of issues unresolved. Because the underlying settlement in Raines expressly excluded a release of PAGA claims, it remains to be seen how the courts will address individual settlements where the releases do include PAGA claims. If a plaintiff has exhausted administrative remedies with the LWDA, then theoretically an individual settlement with that plaintiff that includes a PAGA waiver could be submitted to a trial court for approval, thus barring that individual from pursuing a PAGA representative action based on the same labor code violations in the future. Of course, this would not preclude any other employee from bringing a representative PAGA claim. It's unclear how courts would view such a request for individual approval of a PAGA settlement, as some courts have held that a PAGA claim can never be an individual one, such as the appeals court in Kahn v. Dunn-Edwards. Also unresolved is whether pre-litigation settlements with individuals can effectively release PAGA claims, such as via a severance agreement. Such an agreement should not require court approval, as the statute provides that only civil actions filed pursuant to PAGA require court approval. However, it's unclear whether an individual who has not exhausted administrative remedies with the LWDA could effectively release their claims under PAGA. In Julian v. Glenair, the Court of Appeal held an employee cannot enter into an agreement affecting a PAGA claim prior to being authorized by the LWDA to pursue it. The agreement in that case was an arbitration agreement, not a settlement agreement, but the same logic could apply to a settlement agreement. Now, potential strategies to ensure that an individual pre-litigation settlement effectively precludes the settling individual from pursuing PAGA claims include the use of a covenant not to sue and a Civil Code Section 1542 waiver. A covenant not to sue is an agreement not to enforce an existing cause of action. It does not constitute an abandonment or relinquishment of an existing right or claim. In other words, the plaintiff is not releasing any claim, but rather is agreeing not to go to court to enforce the claim. Thus, an employee could potentially agree to not bring suit under PAGA without actually waiving the state-controlled right to serve as a PAGA representative. Because a covenant not to sue doesn't release any state-controlled rights, there would be no need to first go through the LWDA notification process. And in addition, there's also a California Civil Code Section 1542 waiver. This could potentially also provide means to include PAGA claims in pre-litigation settlements. Such waivers are designed to allow an employee to waive an employer's liability for claims that the employee is unaware of at the time they entered into an agreement. The effect of both of these strategies on an employee's right to serve as a PAGA representative has yet to be decided by the courts. Another bad ruling for employers regarding settlements was handed down by the Ninth Circuit in Zamora versus Walgreens. There, the plaintiff had participated in a prior settlement of wage and hour claims based on unpaid overtime and failure to provide breaks, including signing a claim form containing a broad release of all labor code and PAGA claims, plus a covenant not to sue. The plaintiff then filed a separate PAGA action alleging failure to provide suitable seating. The Ninth Circuit held that the release was not enforceable because the two actions were founded on different facts. Right? The first one was for overtime and the second one was for suitable seating, so they were entirely distinct. Res judicata also did not apply since the second suit was based on different claims. Luckily, this decision was unpublished, but it is still an indication as to how the Ninth Circuit may rule under similar circumstances. One way that employers can try to ensure that a broad release is upheld is to insist that settling plaintiffs amend their complaints to add additional claims. While it's unlikely that plaintiffs' counsel will agree to amend complaints to add in every possible type of wage and hour claim, and frankly also unlikely that trial courts will routinely approve such extremely broad releases, it is a good practice for defense counsel to seek to have plaintiffs amend their complaints to add as many reasonably related claims as is possible. One small bit of good news for employers came when the California Supreme Court issued its decision in ZB versus Superior Court. There, the plaintiff had brought a PAGA claim that purported to seek recovery of unpaid wages pursuant to Labor Code Section 558. Some courts had previously held that unpaid wages could be recovered in a PAGA action, and that any of those wages that were recovered would not have to be split with the state of California, unlike PAGA penalties, of which 75% must go to the state. The Supreme Court ruled that the PAGA statute only permits the recovery of civil penalties and not unpaid wages, and also that there is no private right of action to pursue wage claims pursuant to Section 558. This ruling limits the scope of recovery for plaintiffs under PAGA actions and means that claims for recovery of wages, unlike PAGA penalties, can reliably be compelled to arbitration where employees have arbitration agreements. Finally, we want to tell you about a trend that we have been seeing where plaintiffs' counsel filed both a class action suit and then subsequently a separate PAGA action alleging the same underlying wage and hour violations and with the same individual named as the representative in both actions. So why are they doing this? Well, if they filed both actions together, then the entire case could be removed to federal court under the Class Action Fairness Act, including the PAGA claim. However, when filed separately, the PAGA action is nearly immune from removal because only the potential value of the named plaintiff's claims count towards the amount in controversy. The claims of all employees together cannot be aggregated to meet the $5 million threshold under the CAFA. This strategy presents several problems for employers. First, there is the inconvenience and expense of dealing with two nearly identical lawsuits in two different courts, and there is a risk that the courts will issue inconsistent rulings. One strategy that we've had success with is in getting the PAGA action stayed either under Code of Civil Procedure Section 587 or pursuant to the court's inherent authority to manage its docket. Many judges will issue a stay under these circumstances, while other judges may decide to only stay discovery. But either way, seeking a stay is a worthwhile step for employers to take when faced with such duplicative actions. Okay, That's it for our PAGA update. Next up, Carrie Friedrichs will discuss the current status of California law concerning classification of independent contractors.
Thanks, Chris. As Chris mentioned, in this next segment, I'm going to discuss recent developments from courts and the California legislature in the area of independent contractor classification. This is an area in which we've seen many changes in recent years. It all started with a Dynamex case back in 2018. In this case, the California Supreme Court rejected the traditional multi-factor test for independent contractor status and adopted the ABC test. This case led to a flurry of cases and legislation in the independent contractor area over the past 2 years. But before I discuss the legislation, I want to provide a little background on the Dynamex case and the ABC test that was established in that case. For years, employers had relied on the relatively flexible Borrello test, which is a multi-factor test involving a balancing of a variety of factors to determine whether a worker can be classified as a contractor. The ABC test is much less flexible. Under the ABC test, in order to qualify as an independent contractor, a worker must meet all 3 of the ABC requirements. It's not a balancing as it is under the Borrello test. So the first factor, the A factor, is that the worker must be free from control and direction of the hiring entity in connection with performance of the work, both in contract and in fact. Factor B is that the work performed by the worker must be outside the usual course of the hiring entity's business. And factor C is that the worker must be customarily engaged in an independently established trade, occupation, or business. In other words, the individual must be actually operating an independent business. The Dynamex case involved delivery drivers who worked for delivery service. Therefore, factor B was a particularly problematic factor for the company. This is the factor that has presented issues for many companies using independent contractors because many workers perform services that are within the usual course of the hiring entity's business. An example of an exception to this would be a plumber or another specialized skilled worker who comes in and provides a specific service that is unrelated to the company's core business. We expect that court decisions in the next few years will continue to clarify what it means to be working in the usual course of business and will clarify other parameters of the elements of the ABC test. Next slide, please. So after the Dynamex decision, courts stepped in pretty quickly to clarify some of the key issues in application of the ABC test. I'll just note 2 particularly significant cases, Curry v. Equilon Enterprises and Vasquez v. JanPro Franchising. First, in Curry, this case involved claims that were made by an employee of a gas station operator, and the employee alleged that she was jointly employed by Equilon Enterprises, which is Shell, which had leased the gas station to the gas station operator that employed her, and also leased gas stations to hundreds of other independent operators. The gas station operators ran the stations totally independently and hired their own employees. The plaintiff argued that she was actually Shell's employee too, claiming that the ABC test should have been applied to determine her employment status and not the more flexible multi-factor test the trial court had applied in finding she was not Shell's employee. In other words, she sought to extend Dynamex to the joint employment context. The Court of Appeal declined to apply the ABC test to determine joint employment, and it held that policy reasons for selecting the ABC test are uniquely relevant to the issue of allegedly misclassified independent contractors. It noted that in the joint employment context, there already is a primary employer that pays taxes on the behalf of the employee, and the employee has legal employment protections through that employment relationship. These policy considerations that underlie the ABC test just don't apply where the individual was already another entity's employee. So this case came as a big relief to employers that were concerned that the Dynamex test would be extended to cover all questions regarding employment status, including those outside the independent contractor context. The second very significant case that I want to discuss today is Vasquez v. JanPro Franchising. In this case, the Ninth Circuit addressed the question of whether the Dynamex decision had retroactive application. Unfortunately, the Ninth Circuit answered that question in the affirmative, finding that Dynamex was declarative of existing law and applied retroactively. The court rejected Jan Pro's arguments, which were that Dynamex could not be applied retroactively because this would violate the due process rights of companies that had reasonably relied on the long-standing Borrello test. However, shortly after the Ninth Circuit issued its decision, the decision was vacated, and the question of whether Dynamex applies retroactively was certified to the California Supreme Court. This issue has now been fully briefed, and oral argument was actually held just a few weeks ago. The answer to this question will have a significant impact on companies facing potential retroactive liability for contractors who do not meet the requirements of the strict ABC test. Next slide, please. So while plaintiffs were filing lawsuits claiming that they were misclassified under the ABC test, the legislature was also busy preparing legislation to codify and expand the ABC test. The first bill that passed was AB 5 in 2019. AB 5 was a result of significant lobbying from many interests, including, on one hand, employee rights groups and unions seeking to expand application of the test to more workers and to apply to more types of claims. And on the other hand, we had employers and industry groups and workers who wanted to remain independent, arguing that the test should be more limited. AB 5 codifies Dynamex and established the ABC test as the test that would determine employment status for a variety of employment purposes beyond the laws at issue in the Dynamex case. Dynamex was limited to claims under the wage orders. A large number of industry groups pushed for exemptions from the law. Some of them were successful and some of them were not. In response to these lobbying efforts, AB 5 included a number of exemptions, including exemptions for certain specified occupations, including physicians, lawyers, dentists, architects, commercial fishermen, real estate agents, and a number of other specific occupations, and for certain business-to-business relationships and relationships between referral agencies and specific workers that use the referral agency's referral services. One important thing to keep in mind is that if an exemption from the ABC test applies, that does not automatically mean that the worker qualifies as an independent contractor. It just means that the more flexible Borrello test applies to determine if that worker can be classified as a contractor. So what happened after AB 5? As anticipated, many more groups of workers and businesses that engage with those workers were not happy with AB 5, and they could not understand why some workers and industries were provided with exemptions and others were not. So the 2020 legislative session was again filled with lobbying efforts on behalf of these industries and workers. Next slide, please. So now we have AB 2257 after a year and lots of lobbying. AB 2257 replaces AB 5. It took effect immediately upon its passage in September of 2020. And essentially, it preserves the overall scope and structure of the legislation, but the tests now have been modified in part to reflect some of the lobbying efforts that took place after AB 5. Some industries were able to secure exemptions and some were not. It's likely that those that did not may continue their lobbying efforts in the next legislative session. Some notable changes in AB 2257 are that it significantly expanded the professional and referral agency exemptions, which I'll discuss in a minute. It also enhanced enforcement powers, providing district attorneys the ability to file injunctive relief actions against businesses suspected of misclassifying workers. Previously, only the Attorney General and certain city attorneys of large cities were able to file such actions. AB 2257 made many other changes. The discussion of all of the implications of this bill would fill an entire day, so I'll just touch on a few of the major changes. Next slide, please. So AB 5 had already exempted many different types of professionals from the ABC test, but it was a limited group and the bill contained significant restrictions that had a huge impact on workers in certain professions like journalism. The professional services exemption still contains, after AB 2257, a collection of specific individual professions, including some industries and not others, and there's still no clear rhyme or reason as to many of the exemptions, but now there are more of them. One of the aspects of AB 5 that generated a lot of attention in the media was its limitation on the number of submissions that freelance journalists and other freelancers could publish in a single publication without losing their ability to work as freelancers. AB 2257 removes the submission cap and instead requires that businesses that contract with freelancers refrain from displacing existing employees in order to work with those freelancers. Next slide, please. AB 2257 also significantly amended the business-to-business exemption from the ABC test. The business-to-business exemption recognizes bona fide business-to-business contracting relationships, which are where two businesses contract with each other, where one of them may be a one-person operation operating as a sole proprietor or other type of business entity. 12 different requirements apply to determine if that individual really is operating as an independent business. If any one of those requirements is not met, the ABC test will apply. If all of them are met, then the Borello test will apply. The intent of this test appears to be to make sure that the ABC test applies where a business requires an individual or encourages an individual to set up a corporate entity as a way to avoid employment status. But the legislature does not want or recognizes that the ABC test should not apply where the person really is operating an independent business. AB 2257 changed several aspects of the business-to-business exemption. First, it clarified the type of work that service providers can perform. Under AB 5, the business-to-business exemption did not apply if the service provider performed work for the hiring business's customers. Under AB 2257, business service providers are allowed to provide work for the hiring business's customers if the business provider's employees, which may just be one person if an individual is operating as a business, are solely performing the services under the name of the business services provider, and the business services provider regularly contracts with other businesses. That was a significant expansion of this exemption. Second, the business-to-business exemption now requires that a contract must be in writing, setting forth the payment amount, rate of pay, and due date for payment. So that's an important requirement to remember. Third, the amendments to the business-to-business exemption now provide that the business services provider does not actually have to provide services to others. AB 5 had required that these entities actually contract with others in order to qualify for this exemption. Now they just need to be free to provide those services. Next slide, please. AB 2257 also includes clarifications of the referral agency exemption. This exemption was designed to provide that the ABC test does not apply to determine if a referral agency is the employer of the individuals who it is referring to customers. The original referral agency exemption in AB 5 was very limited, applying only to a very limited set of services, including tutoring, minor home repair, moving, home cleaning, dog walking, dog grooming, picture hanging, pool cleaning, and a few other types of services. It was not clear why the exemption was limited to these particular services. AB 2257 significantly expands the exemption, expressly applying it to a non-exclusive list of additional services. The referral agency exemption also clarifies some requirements that are designed to ensure that the service provider really is operating as an independent business. For example, the service provider must certify that it has complied with applicable business license and tax registration requirements, where those requirements apply. There's also now more flexibility in connection with the requirement that the service provider be customarily engaged in independent business. There's more of a focus now on making sure that the referral agency does not restrict the business from working with others. Another clarification is that the service provider must be able to set the hours in terms of the work, or to negotiate them directly with the client, or the business service provider can negotiate them with the client through the referral agency. There are many other exemptions in AB 2257, including an exemption for single engagement contracts, where individual businesses that contract with one another for purposes of providing services at the location of a single engagement event can be exempted. This is where an individual contracts with one other business to perform services at a standalone, non-recurring event in a single location or a series of events in the same location, no more than once a week. So this was a very helpful exemption for those who host these single engagement events. There's also a significant carve-out for the music industry, for performers and other workers, subject to many different specific and complicated criteria. These exemptions are very specific to the music industry, and many others in the entertainment space were not provided with similar exemptions. And we don't know why, other than that some were more successful in lobbying efforts than others. And with that, I'll hand it over to Michael Afar to discuss developments in the area of off-the-clock work.
Thanks, Carrie. So off-the-clock claims are something that employers regularly see in class and PAGA actions in California. And a little bit of a history lesson is helpful. These types of off-the-clock class claims have been challenging for courts to certify historically, particularly after the California Supreme Court's decision in Brinker, where the California Supreme Court held that in the absence of a uniform company-wide policy, proof of off-the-clock liability would have to continue in an employee-by-employee fashion, demonstrating who worked off the clock, how long they worked, and whether the company should have known of that work. However, in recent years, we've been seeing a rise of off-the-clock claims in the class and PAGA sphere under theories of liability that present more uniformly across employees. And this is one of the most difficult issues facing employers for these types of claims, where the plaintiffs can point to a policy or a practice where all employees necessarily have to engage in some level of work off the clock. Some of the most common examples that we've been seeing are things like bag checks, security inspections, having to perform some sort of activities after clocking out, such as running reports, setting alarms, shutting down computer systems, even things like donning and doffing equipment. And historically, employers have been able to fend off such attacks by relying on the de minimis defense. And Troster v. Starbucks Corp. From 2018 was a huge decision by the California Supreme Court that gutted that de minimis doctrine. And in that case, the California Supreme Court considered the issue of whether the federal de minimis defense, under which daily periods of time of up to 10 minutes per day were non-compensable, whether that applied to claims under the California Labor Code. And the answer was no. The key language from the court in Troster was that the relevant California statutes and wage order have not incorporated that federal de minimis doctrine, and they don't allow employers to require employees to routinely work for minutes off the clock without compensation. However, it left open the question of whether there could be some wage claims involving employee activities that are so irregular or brief in duration that employers may not be reasonably required to compensate employees for the time spent on them. The facts in Troster specifically involve time off the clock ranging from 4 to 10 minutes per day. And so the issue the court faced was, what do we do about smaller periods of time? What about those activities that are only a few seconds or 1 minute or 2 minutes every day? Where is the threshold for what irregular is or for what is enough to be deemed brief in duration? After 2018, the Ninth Circuit faced this issue in a case called Rodriguez versus Nike Retail Services in 2019. And the Rodriguez decision was the first Ninth Circuit appellate case to address the holding in Troster and whether the federal de minimis doctrine applied under California law according to the Federal Circuit. This was a case involving bag checks or security inspections. These were post-shift activities where employees would need to stop and wait for a manager to inspect their bags to ensure that there was no theft and to prevent any loss prevention. And so the Ninth Circuit held that the rule in Troster mandated compensation where employees are regularly required to work off the clock for more than minute or brief periods of time. And it still followed that same rationale in Troster, which is that there may be some level of time, if it's minute or brief or trifling, that may not need to be compensated. However, again, the Ninth Circuit didn't take that additional step to say what that threshold was. And so even though this decision was the proverbial nail in the coffin of the federal de minimis doctrine as it used to apply in California, it still confirmed that there still may be some hope that some amount of time may not need to be compensated. The question of how much that is or how regular that is still undecided in California and federal courts in California. Following these lines of cases for off-the-clock work, there was a key decision in 2020 against Apple. In this case, employees brought a wage and hour class action against the employer seeking compensation for the time spent waiting for and undergoing exit searches pursuant to Apple's bag check and package search policy. This case was a little bit different from other bag check cases in that there was a voluntary aspect to it. And this addressed another defense argument that's been raised by employer, which is that if there is a voluntary nature to the activity in question, that should preclude liability against the employer for any work off the clock. In other words, if the employee can avoid the potential activity that would trigger off the clock work, then that should also preclude the company from being held liable for paying for that time. The California Supreme Court considered this question as it was certified to them from the Ninth Circuit, and the question was whether an employee who engages in that time spent to inspect their bag, even if they voluntarily chose to bring that to work, does that constitute compensable hours worked under California law? And the answer to that question was yes. The court held that mandatory exit search process, even if they chose to bring that bag or cell phone to work that day, was an employer-controlled activity, and so it was deemed compensable hours worked within the meaning of the California wage order. Apple had argued that this time was not compensable, again, because the employees could avoid the whole process, but the court disagreed. And this was an important holding because it shut down a huge defense that a lot of employers have relied on of the voluntariness nature of all of these activities. And the reason why the court said that was because even if the activity was voluntary, there was still a layer of control for a few reasons. One, Apple required the employees to comply with the policy under a threat of discipline up to and including termination. Second, Apple confined its employees to the premises as they waited for and underwent the exit search. Third, Apple forced the employees to perform specific and supervised tasks while awaiting and undergoing the search, including locating a manager or a security guard and waiting for that person to become available, having to unzip and open their bags and packages and move items around. And all of that provided a certain threshold level of control that constituted hours worked. The court also gave some guidance as to what other employers and courts should consider when determining whether the particular activity rise to a level of control to be deemed compensable time work. One was the location of the activity. The other was the degree of the employer's control. Another was whether the activity primarily benefited the employee or the employer. For example, here, it primarily benefited the employer because of the loss prevention issues. And finally, whether the activity is enforced through disciplinary measures, such as evaluating whether the employee could be subject to discipline for failing to adhere to that particular policy. One sort of nuance from this case was, even though it involved the issue of whether the time spent was considered hours worked, the issue of how much time was in play was not addressed. And after the Ninth Circuit received this answer from the California Supreme Court, it reversed the lower court decision and granted summary judgment for the plaintiffs on the hours worked issue, but it notably revised the language in its order just a few weeks ago to allow the parties at the lower court level to now make new arguments about whether the time spent undergoing those searches could still be considered de minimis. And so this brings us full circle back to the issues in Troster and in Rodriguez as to what amount of time can still be considered de minimis. And there still is an avenue that employers can proceed with to try to convince a court that even if this is a regular activity, even if it is something that all employees are doing pursuant to a company policy or practice that may otherwise be certifiable, that there should not be any liability because the amount of time is so small. Many of these class action cases for off-the-clock work rely on heavy penalties to increase exposure and to pressure employers to settle for high amounts of money, millions of dollars. This is because just a few seconds or minutes of time off the clock can translate to thousands and thousands of dollars of potential penalties, whether that's through wage statement penalties for not listing all of the time worked on the wage statement, or for waiting time penalties because you didn't pay out all the time worked at the time an employee was terminated, and even the PAGA penalties that would tack on to all of these claims. And one defense that we've still seen stick around in these class action cases for off-the-clock work is the good faith dispute. That good faith dispute defense was most recently applied successfully in the case of Chavez v. Converse in the Northern District of California in March of 2020. Converse sought partial summary judgment to dismiss the wage statement penalties and the waiting time penalties on the ground that it had a good faith belief that the time spent in bag checks and exit inspections was not compensable. Part of that was based off of the prior federal de minimis doctrine that existed before the Troster decision, and part of that was also in the post-Troster world, where even Troster has left the question of how much time is compensable open to interpretation, and there's no threshold that's been determined. And so the court held that California courts regularly applied the prior federal de minimis defense, and so Converse had acted reasonably in asserting that de minimis defense given the legal landscape at the time. More importantly, the court held that even after Troster, the precise contours of the de minimis doctrine remain uncertain, and this uncertainty alone presents a good faith dispute. And so with that good faith dispute, the court dismissed the wage statement penalties and the waiting time penalties, which gutted a significant amount of potential exposure in that case. And when you face that situation, these class action claims result in just, potentially just thousands of dollars of unpaid off the clock time, which then completely changes the scope and strategic approach to these types of class action claims. While bag checks and security inspections and some other traditional on-site activities have made up the bulk of recent off-the-clock class action claims in the past years, a new trend that we're seeing is for types of claims that arise in the new COVID world. And one of those issues that we're seeing pop up more often is working from home, especially as businesses are shut down and employees are working from home either on a part-time basis or on a full-time basis. A big issue that employers are facing is how to deal with employees working off the clock when they're not in a work environment where they can be monitored and subject to some sort of discipline or control. And the work from home situation creates numerous opportunities for employees to work without the employer's knowledge. They might not realize that their shift is over, might respond to an email. They might start working earlier and forget that they needed to clock in. There are a host of different things that can happen, and because they're not in a traditional facility or a store or a warehouse, it presents a lot of situations where there could be off-the-clock claims. And one of the issues that was raised in the Brinker case by the California Supreme Court was there needs to be a knowledge of this off-the-clock work. And so how would a company have knowledge in these situations, and how can that knowledge be imputed to the employer? One of the ways that we're seeing plaintiffs approach these cases is by resorting to emails, pointing to emails and asking for it in discovery to show that the employer, these managerial level employees, were constantly aware that non-exempt hourly employees were emailing them off the clock or after their standard shift times to do things that could constitute work, and that the employer should have known that that time was compensable. So a few of the recommendations we have to deal with the work from home environment now, especially in the COVID world, is to make sure that employers are reiterating their existing policies to ensure that there's no work permitted off the clock, updating policies to reflect work from home scenarios, and let employees know these are some common situations that might result in off-the-clock work, and make sure that you're letting us know so you get paid for it, sending reminders for employees to submit all their time work, potentially implementing attestations, and also disciplining employees quickly and with documentation. Other activities that we're seeing trigger compensable time are requirements that are imposed by either the state or local governments for certain pre-shift and post-shift activities, such as temperature checks, donning and doffing personal protective equipment, completing certifications that employees have complied with self-check safety procedures, having to wash their hands or use hand sanitizers, or waiting for other employees to complete these procedures before entering or exiting, what we commonly refer to as waiting time. And all of these situations could arguably be considered off-the-clock work, and because these are requirements that would apply to all employees, they present very attractive theories of liability that we anticipate plaintiffs are going to bring more and more frequently, especially if employers haven't taken the active steps to ensure that that time is being compensated for their employees. The best practice that we're seeing clients implement and other employers implement is to consider automatically paying employees a set amount of time per day, whether that's 2 minutes or 5 minutes or 10 minutes, and to have a written policy to this effect. There's a way to sort of audit the process and see how long these different activities take throughout the day and add it up into a set number of time. And that helps with the class action defense, because when an employee brings an off-the-clock claim as a class action, the fact that some employees have been paid and fully reimbursed for that time and compensated means that there would be no liability. And so determining which employees have been harmed or which employees have not been harmed would arguably be an individualized issue and an employee-by-employee inquiry. And those types of arguments would help an employer get around the class action, especially where there are practices that apply to all employees. This is a good time to remind everybody for the CLE submission. Again, you'll be receiving a follow-up email in the coming days with the CLE submission instructions. The code that you'll need to receive CLE credit is SS2237. Again, that's SS2237. And next, we'll have Carrie Friedrichs to discuss California's new rule prohibiting employers from requiring workers to sign arbitration agreements.
Great, thanks, Michael. So AB 51 became effective in 2020, and it prohibits mandatory agreements to arbitrate employment claims. Next slide, please. Prior to enactment of AB 51, employers were free to require employees to arbitrate employment claims as a condition of employment, provided that the arbitration agreement met specified procedural and substantive requirements. AB 51 changes this and now makes it unlawful for employers to require mandatory arbitration agreements, even if employees are permitted to opt out of them. The employer can't require the employee to take affirmative steps to avoid arbitration. This new law reflects California's general aversion to arbitration agreements, which we've seen in our case law. AB 51's prohibition on mandatory arbitration applies to all claims under the FEHA and under the Labor Code. The bill also contains provisions prohibiting an employer from retaliating against an employee or threatening retaliation against an employee for refusing to consent to an arbitration agreement. Voluntary arbitration agreements are still permitted, so employers are free to offer arbitration agreements to employees as long as it's clear that they're voluntary. Mandatory arbitration can still be included in certain agreements, post-dispute settlement agreements, and negotiated severance agreements. Next slide, please. So AB 51 was pretty much immediately challenged on the grounds that it's preempted by the Federal Arbitration Act. This was expected, as the issue of preemption had been raised throughout the legislative process, and similar bills had been proposed in past years and the preemption issue had been raised in discussion of those bills. The prior version of AB 51 that had been presented to Governor Brown was vetoed by Governor Brown for the stated reason that it plainly violates federal law. The Chamber of Commerce filed the lawsuit challenging AB 51 along with several trade organizations. They argued that AB 51 is preempted by the FAA because it both discriminates against arbitration agreements and interferes with the objectives of the FAA. The court agreed and has enjoined state law enforcement as to arbitration agreements that are governed by the FAA. The preliminary injunction does not address the rights of private parties to bring claims under AB 51. It applies only to government actions. However, the court's analysis in the Chamber of Commerce case may provide guidance for a court's analysis of the same preemption arguments in connection with a private lawsuit to enforce AB 51. So the next question is, what do employers do now? While government enforcement of AB 51 is enjoined, the law is still in effect and its future is uncertain. In the meantime, employers need to decide what to do about arbitration. Part of the analysis depends on when the employer and employee entered into the arbitration agreement. If this agreement was reached before 2020, AB 51 does not impact its enforceability. AB 51 applies only to contracts entered into on or after January 1, 2020. If an employer did not have an agreement in place before 2020, one option to consider is an optional arbitration agreement, as these remain lawful and enforceable. Another issue to consider is whether you really want to have an arbitration agreement. While arbitration can be less costly and more efficient than proceeding in court, and you can avoid certain class action claims with an effective class action waiver that you can include in an arbitration agreement, arbitration may not be the best forum in all cases. Many plaintiffs' attorneys are now bringing PAGA-only claims, as California law currently does not permit employers to compel PAGA claims to arbitration. We've also seen a significant increase in plaintiffs' attorneys filing large numbers of arbitrations. They often recruit thousands of claimants through social media or digital media advertising and file mass arbitrations. These can be very expensive and also very complex to manage. So in short, there's no easy answer, and the approach will really depend on many considerations. And with that, I'll turn it back to Chris to discuss key wage and hour cases that the California Supreme Court currently is considering.
Thanks, Carrie. This past year, the California Court of Appeal issued 2 wage and hour decisions that were extremely rational and well-reasoned, and they were quite favorable to employers. So naturally, the California Supreme Court immediately granted cert as to both of them. The first case is Naranjo versus Spectrum Security Services. There, a court of appeal ruled that unpaid meal period premiums do not trigger the obligation to pay derivative wage statement penalties or waiting time penalties. And in reaching this decision, the Court of Appeal considered prior Supreme Court cases interpreting the nature of meal and rest period premiums. Murphy versus Kenneth Cole held that actions to recover premiums are subject to the 3-year statute of limitations applicable to wages, and not the 1-year applicable to penalties. However, in Kirby versus Immoose, the Supreme Court found that meal and rest premiums do not constitute unpaid wages. In Kirby, the court noted that a claim brought pursuant to Labor Code Section 226.7 is based on the employer's failure to provide meal and rest periods, with the premium pay being the remedy. This claim is not based on the failure to pay wages or premiums. The Supreme Court's logic in Kirby was echoed by the Court of Appeal in Ling versus P.F. Chang's. There, the court held that unpaid meal and rest premiums do not support a claim for waiting time penalties. Echoing Kirby, the court noted that a Section 226.7 action is brought for the non-provision of meal and rest periods, not for the non-payment of wages. Let's go to the next slide. Now, the California Supreme Court denied cert in Ling, which would seem to be an endorsement of the reasoning in that case. However, And one might hope that would mean that the Supremes would apply similar employer-friendly reasoning when they rule on Naranjo. However, several district courts have opined that the expansive language from Ling that I just read a moment ago was merely dicta. These district courts have held that a plaintiff may pursue claims seeking waiting time penalties on the basis of unpaid meal and rest premiums. So there really is quite a bit of uncertainty as to what the court may ultimately determine. The next case to keep an eye on is Farah versus Lowe's Hollywood Hotel. There, the Court of Appeal ruled that meal period premiums should be paid at an employee's base hourly rate rather than the regular rate of pay. The court also held that where an employer has a neutral policy of rounding employee time up or down in equal increments, that policy can be considered fair and neutral and thus lawful even where a majority of workers have net amounts of time rounded away and thus lose compensation. And the Supreme Court granted cert on January 22 of this year. It's not clear how the California Supreme Court will rule in FARA, as they have not issued prior decisions touching on these issues. We need to move to the next slide, please. Our view here at Seyfarth is that the Court of Appeal got it right. First, as to whether premiums should be paid at the regular rate of pay, this would create an administrative and financial burden for employers, similar to the burden of constantly calculating and recalculating the regular rate of pay, and then paying small additional amounts of wages whenever employees receive bonuses and work overtime. However, the language of Labor Code Section 226.7 itself seems to indicate that meal and rest premiums should not be paid at the regular rate of pay, because it states that they are to be paid at the, quote, regular rate of compensation. Elsewhere in the Labor Code, such as in Section 510, the legislature did in fact use the term regular rate of pay. So we must assume that the legislature, in their great wisdom, made a deliberate choice not to use the term regular rate of pay in connection with meal and rest premiums, and thus intended that premiums be paid at an employee's base rate. As for rounding of time, we think that the Court of Appeal in FARA got it right when they ruled that the fact that a majority of workers lost time due to rounding does not necessarily render a rounding practice improper. The leading precedent in California on rounding of time is the See's Candy case, where the Court of Appeals held that rounding is permissible under California law if it is fair and neutral on its face and is, quote, used in such a manner that it will not result over a period of time in failure to compensate the employees properly for all time that they have actually worked. A rounding policy that is fair and neutral on its face has been held by a number of courts to mean one where the amount of potential time that could be rounded to add to an employee's work time is the same as the amount of potential time that could be rounded off. For example, where time is rounded up or down to the nearest quarter hour, and there's no other policy or practice that causes employees to only clock in early rather than late. Under such a scheme, the practice is fair and neutral on its face. However, more uncertainty exists as to what it means for a rounding practice to be used in such a manner that it will not result over a period of time in a failure to compensate the employees properly for all the time they have actually worked. Of course, plaintiff's counsel will typically argue that if they total up all the time added and subtracted from each employee's record, and an employee ends up having more time rounded away than is added, this amounts to a legal violation. This approach is unrealistic, however, because regardless of how fair or neutral a rounding practice is, some employees will sometimes clock in early and some will clock in late, and it would be very unlikely that every employee's time record would even out exactly. Further, it also depends on the time period that one looks at. During one given week, a group of employees or a specific employee may lose time, but in the next week they may gain time. Ultimately, the determination of whether a rounding practice is lawful should not depend on whether employees actually gain or lose paid work time, but whether there is something about the rounding practice or related policies that causes employees to have more paid work time rounded away than is added to their record. In AHMC Healthcare, the Court of Appeal ruled that a rounding policy was lawful, even where certain employees were undercompensated, because the evidence established that the rounding system, quote, did not systematically undercompensate employees over time, end quote. The key word here is systematically. In other words, is there something about the system in place that causes employees to lose time? For example, if an employer has a neutral policy of rounding up or down to the nearest quarter hour, but the employer also considers an employee to be tardy if they arrive at their workstation 5 minutes after their scheduled start time, then the interaction of these two policies will likely result in excess time being rounded away. That would be a systematic reason why more time would be rounded away than added. On the other hand, if an employer has a very diligent workforce that tends to clock in early, resulting in more time being rounded away than is added to their time records, then this should not result in legal liability. Hopefully, when the Supreme Court issues its decision in the FAIR case, it will come to a similar conclusion. And finally, we're almost out of time, but Michael will briefly tell us about some additional wage and hour developments that have occurred recently.
Thanks, Chris. And just to clarify, the prior CLE code, we inadvertently left off one digit. The correct CLE code is SS, as in Seyfarth Shaw, 22371. Again, that's SS 22371. We are almost out of time. We're a little bit over. So just to highlight a few key decisions from 2020. One decision is David versus Queen of the Valley Medical Center. It was a case where rounding, which is still a hot area in wage and hour class actions now, the Court of Appeal in California held that the summary adjudication on a rounding claim was appropriate, where the employer can show the rounding policy doesn't systematically underpay the employee, even if the employee loses compensation over time. In that case, the rounding practice had 53% of the rounded time favoring the employer, and the plaintiff lost on average 1.5 minutes of time per shift. And the court said that that policy applied neutrally up and down for employees, and that small amount of time was not a statistically meaningful amount of time whereby there could be liability. And it's reaffirmed prior California Court of Appeal authority where rounding has been held neutral even if a plaintiff lost on 51 or 55% of the time and lost even more than 2 minutes per shift. Another case is McPherson v. EF Intercultural Foundation. It's a case involving unlimited vacation policies. And while some employers are considering moving away from unlimited vacation in California, after McPherson, many are still choosing to continue with these policies. And so the decision in McPherson pretty significantly increases the risk that an unlimited vacation policy could be deemed an accrual-based policy unless the amount of time is truly unrestricted. And there are a few key factors to consider there, including that employees must be informed that their right to take the paid time off truly is unlimited. They need to understand that they're leaving a benefit on the table if they choose not to use it, that employees must have a real opportunity to take that time off, and that there can be no expectations regarding a minimum or maximum amount of time off there. Finally, the last case is Barriga v. 99 cents only. It involves a situation where plaintiffs had attacked the declarations obtained by the defendant from current employees to support an opposition to class certification, claiming that they were coerced. The California Court of Appeal held that these types of declarations from current employees are inherently coercive and must be scrutinized by the trial court judge to determine if there was some coercion and whether those declarations were truly voluntarily provided. The plaintiffs had moved to strike the declarations because some of the employees who were deposed said that they didn't know why they were at the deposition, they didn't have a chance to review the declarations before signing, and that people just showed up at their work and gave them something to sign. And so the California Court of Appeal sent the case back down to the trial court to evaluate whether there was some sort of coercion involved there, because the trial court hadn't adequately considered whether there was that abuse there with those declarations. And that's something that we're seeing being attacked more and more often by plaintiffs' counsel in these cases, especially because the declarations are so crucial to create a conflict of evidence that courts are looking for to deny class certification motions. And
Great.
it looks
Thanks,
like we had a
Michael.
lot of questions. Yep, go ahead, Chris.
Oh, I'm sorry. Yeah, we're out of time for questions, but we will get back to you in the coming days via email to respond to your questions. Thank you for attending today's webinar. We really appreciate it, and we hope to see you next year.